Supreme Court in a major victory for school choice and religious liberty. We'll talk about it today on the broadcast. And a big victory out of the Supreme Court today, 5-4, with Chief Justice John Roberts writing the majority opinion for the court in what you'd say maybe the right way. This is a school choice case, the Espinoza case. It's one we talked about on the air when we launched our school choice initiative. It just, for folks out there said, well, why now? It's not something the ACLJ has obviously never been involved in. We've been involved with it for a very long time. Before it was something that was in fashion to even talk about, and when it was really just starting in the states across the country, and they've been working through these laws that date back on the books to the 1800s and about whether or not states can fund religious institutions at a time or any kind of religious groups, even if you have these voucher programs where it's really supposed to be up to the parents to make that decision. And I think now we're starting to see the erosion of that idea that you can somehow distinguish between a private school that's not affiliated with a religious group and one that is.
No, they're
both nonprofits.
That's correct. And we had a case a number of years ago for Josh Davies versus Locke, or Locke v. Davies. And there the court ruled that you cannot compel a government to pay for the seminary training of a student. What's interesting about this case is, first, it limits significantly the holding in Locke v. Davies. And in fact, it says this: we've repeatedly held that the Establishment Clause is not offended when religious observers and organizations benefit from neutral government programs. See Locke versus Davies, 540 U.S. at 719. So that's great. It limited that holding and then protected the religious institutions or people that want to choose a religious school among many options for school choice. So that it's a very positive decision by Justice John Roberts. Also, Justice Sam Alito wrote a concurring opinion on which he obviously agreed that the funds could be used for religious training, religious schools. And he cites a law review article that I wrote with a colleague, Jeremy Tedesco, who was my law clerk at the time. That was part of my dissertation, and this was an adaptation from my dissertation. For those watching on TV, we have it up on the screen. And in it, I wrote that I talked about the Philadelphia Bible riots and the anti-Catholic animus that led to what's called the Blaine Amendments, which were these anti-religion. They were aimed at Catholics, but could have been really aimed at anybody. And Justice Alito cites my law review article in two separate footnotes. First time that's happened. We've had our brief cited in cases. We filed a brief in the case as well. But I've never had the law review article that we wrote cited. And here it is. This is the law review article cited in a just Supreme Court decision. So we've been working on this issue, folks, for, as you can tell, the article itself is 15 years old. Okay, it was in 2005 is when it was published. We've been working on this issue for almost 30 years. 15 of it shows up in this Supreme Court decision. And I think you understand how important this issue is to us and what a significant day this is for the ACLJ and for the United States, for that matter.
Folks, we have a brand new school choice initiative launched by the American Center for Law and Justice. You can check it out at aclj.org, but we need your support. I think as you can see through our broadcast and our show today, there needs to be a lot of education here because it is transformative what we're proposing with the school choice initiative. Check it out at aclj.org and support the work of the American Center for Law and Justice so we can continue to expand these initiatives. That's at aclj.org. You can donate today at aclj.org.
Thanks to your support of the ACLJ, we have had many victories.
The IRS now formally apologizing to Tea Party groups.
If any group feels like they're being targeted, they can go to federal court and bring our case. That's a victory.
It's one of the most significant wins in the ACLJ's history, to take on the IRS and win.
For more than 27 years, the ACLJ has been fighting for freedom and liberty in the United States and around the globe.
These are young people in their 20s and 30s that are doing this, are fighting for life at a whole new level to beat back the abortion juggernaut. But I actually think we're winning this. This is one of the social issues we're winning.
The release of Andrew Brunson.
We're flying and they finally left Turkish airspace. It's like, okay, we're really out of Turkey and free again.
We need your help as we continue this work here in the United States and around the world. Join us online at the American Center for Law and Justice at aclj.org.
This is a 5-4 decision out of the U.S. Supreme Court. Chief Justice Roberts writing the majority opinion here. And the court, it's a victory for religious liberty, but in the scheme of kind of how things are going around the country, for states who are trying to broaden out their school choice initiatives. Remember we talked about that in Florida, which is not making a lot of news, but the Wall Street Journal picked up on it out of Florida. They expanded their school choice program another 30 or 40,000 students who will be eligible for that program. But some states throughout the country have these laws on the books, and we talked about that when we launched our school choice initiative, that laws on the books that tried to prohibit having any kind of money going to religious institutions whatsoever. So if it was a religious school with any kind of affiliation whatsoever. But the target at the time was 100% on Catholic education because there was no other major religious education going on in the country. So this goes way back in our history. At a time, it was pretty bigoted law, a law that would not stand in these days, right? I mean, there's no way laws like this would be adopted. Yet how states tried to modernize them was, we're just not going to fund any religion whatsoever. And what they've said here is, if you're going to have a program you can choose any school you want, including private education.
That's what it says.
You can't say, oh, that private school's okay, but the one with the priest or the one with the pastor or the one that has chapel once a week, regardless, or the Islamic school, Jewish school, go down the list, Hindu school, all the different religious groups we have is not going to be excluded.
Well, what it says is any establishment clause, which is church-state separation. So any establishment clause objection to the scholarship program here is particularly unavailing. This is what Chief Justice Roberts said, because the government support makes its way to religious schools only as a result of Montanans independently choosing to spend their scholarships at such schools. What's also interesting, I'll get to this in a moment. I argued in the Santa Fe case, which I didn't see that in here, which was another one that didn't go our way, and we had about 3 of our 20 that did not go our way. And these were always tough cases. And I argued that there should be play in the joints in the Establishment Clause doctrine, which they didn't adopt there. But here they said, the religion clauses of the First Amendment provide that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. We have recognized a, quote, play in the joints between what the Establishment Clause permits and the Free Exercise Clause compels.
If you want to fundamentally change and not have your cities burning down and figure out kind of culturally, civically, as a country, how do we move forward? Well, if you don't improve education, so if people's life starts out already in deteriorating schools, it's like we've thrown so much money at this problem. Obviously, money's not the answer. Yeah. You can increase salaries. I don't even necessarily, it's not always the teacher's fault. Sometimes it can be that there's just not the resources. How many trailers do you see outside of public schools? Go to a private school. How many trailers will you see? It's a lot less.
But the idea, some people say, well, this is going to hurt the public schools, which we've written about that. That's completely false. And I want to reiterate.
They always get grants.
I want to reiterate something. Yeah, I want to reiterate something here. I think this is one of the this is one of the civil rights issues of our time. And it is one of the civil rights issues of our time because, and this is important to understand, it evens the playing field so that parents that don't have the resources to send their kids to the private school of their choice, if that's what they want to do, or a charter school, have the ability now to do that. How that hurts education, I don't see it, and we've written about that. But I think giving this equal opportunity grant, which is what it really is, I think bodes well for the future, and I think the Supreme Court got it right as it relates to religious schools. But more importantly than that, it got it right as it relates to parents having that fundamental choice, which is something that we at the ACLJ think is a civil rights issue, the right to an equal and good education. We've been talking about equal equality and equal education since Brown versus Board of Education in 1954. Well, now in 2020, we actually have a mechanism upon which we can do it. And now, today, the Supreme Court cleared the way so that all schools could be included within that parameter, including schools that have a religious affiliation. So I think this is a really good decision The Chief Justice Roberts wrote, I think Justice Alito's concurrence, obviously I'm biased since he's citing my law review article twice, is very, very good.
You know, I saw comments too from folks on Facebook, and they're writing in. They're saying things like, either I wish I had these opportunities with my kids, or we do have these opportunities in our school, and because of that, the public schools have gotten so good they have waiting lists. Public schools have waiting lists to get into.
Yep.
Like multiple public schools within the same district have waiting lists because this has improved. Everyone's had to up their game to the level. And so if you live in a state that's had significant success with these programs, or one that's done it on a wide scale, if you happen to be in one of the places that has benefited the most from it, I don't think you can tell as much of a difference between the public school and the private school. They actually kind of look the same, and the opportunities are kind of the same, and the test scores end up being the same. The teachers are very similar. Resources available to the student are similar. But we all know in the toughest neighborhoods in the country, it does not matter how much money you throw at a problem if you don't have, again, the wherewithal to it's not just all about dollars and cents. Let's put it that way. I mean, the teachers union, look at the kind of money that's spent on per student even. Private schools do it for a lot less, but it costs more money. And this will open the door too. It also makes the private schools, it makes all the education more competitive because it actually makes the parents involved. It gets parents who might not have been involved at all and just kind of think of school as daycare into having to make decisions about where resources are spent. And every parent, regardless of their income, regardless of their background, if they actually have a chance to get involved, the involvement rates go up, 80, 90%. It's amazing to see what these kind of decisions and giving this kind of choice to parents will do. I think this has bigger ramifications too. I think saying that you can't differentiate between religious and non-religious, you can take that to a lot of other potential issues as well. And these states are going to have a tough time trying to make that distinction anymore. Folks, the ACLJ is doing work all across the country on all the issues that you care about, all across the world on the issues you care about. And we're able to broadcast it to you because of your support. We're able to do the work in our country because of your support. We're able to do the work internationally because of your financial support. And this is a great time to make a financial contribution to the ACLJ because it's a matching challenge month. What does that mean? We have a group of donors ready to match every donation that comes into the ACLJ right now at aclj.org. You're literally doubling the impact of your donation. Your $25 donation, that's what you're charged on your credit card. That's like $50 for us to ACLJ. No amount too small, no amount too big. It all makes a huge impact. Go to aclj.org, be part of our matching challenge, and donate today.
For 30 years, the American Center for Law and Justice has been dedicated to protecting your religious and constitutional freedoms. Because of you, we've seen great success in the courts and Congress concerning the issues that matter most to you and your families. ACLJ Chief Counsel Jay Sekulow.
Our decades-long commitment to the Constitution and the rule of law is at the center of everything we do. The bottom line, our work could not take place without your generous support.
It's a critical time for our nation and our world. With so many challenges facing our country, the work of the American Center for Law and Justice has never been more important. There's no better way to support the ACLJ than through online giving.
We truly appreciate your financial support. Without it, it would be impossible to do our work here and around the globe. And the best way to support our work is to make your financial gifts online at aclj.org.
Donating online is safe and secure, and an online gift at aclj.org can be put to work immediately, enabling the ACLJ to continue the battle against abortion giant Planned Parenthood.
These are young people in their 20s and 30s that are doing this, are fighting for life at a whole new level to beat back the abortion juggernaut. We've got a whole group of young lawyers that are defending them.
To protect Christians facing persecution.
Release of Andrew Brunson. He is the American evangelical from North Carolina, held in Turkey for more than 2 years.
We're grateful to ACLJ who put it out to these people, they were getting all this out.
I'm thankful, I'm grateful, and actually I'm astounded.
To stand up for our good friend Israel. To work to uncover the corrupt deep state in Washington, and so much more. Take part in our matching challenge today. You can make a difference in the work we do. Give a gift today online at aclj.org.
Welcome back to Jay Sekulow Live. This is Jordan Sekulow. I want to go right to the phones. Ed White is joining us, too, from the ACLJ. But Rick's got a great call. He's out of Montana online, too. So this is a direct effect. Rick, welcome to Jay Sekulow Live. You're on the air.
Hey, thanks a lot, guys, for taking my call. You know, you make me proud that you guys are doing all this fighting for us, even in Montana. To have something local like that come through the byways is just amazing. But anyway, my question is, does this possibly open the door for using school vouchers or even tax monies towards the Christian schools that we might want to go to?
Yeah, so here's the thing. If there's a voucher program in Montana or in your county where you live, or a district where you live, the fact is they cannot discriminate. In other words, they cannot deny utilization of that voucher fund for parents that make the decision to send their school kids to a religiously affiliated school. So faith-based schools cannot be excluded from an otherwise neutral program. This is a really big decision in two contexts. Number one, there was a case that we were involved in, Locke versus Davies. I argued it, where the court went kind of the other way on this. And then over time, they've been backing down. But now they've really cabined that opinion, which is, by the way, what we asked for in our brief. In fact, I'll read you what we said, Rick, in our brief. We actually asserted, because we knew the Locke versus Davies case would be coming up. We said, argument 2, Locke versus Davies provides no solid footing for a contrary result. And in fact, Chief Justice Roberts not only obviously agreed with that position, which was important, he also noted that we, quote, have repeatedly held that the Establishment Clause is not offended when religious observers and organizations benefit from neutral government programs. And he cited Locke versus Davies. And then, as I said, Justice Alito cited an article that was an adaptation from my PhD dissertation, a law review article that I published in Pepperdine Law Review with a colleague of mine who was my law clerk, Jeremy Tedesco. He's now with ADF. And we wrote this 15 years ago. So this is an issue, Rick, we've been involved in for literally 3 decades. And now, 3 decades worth of work, we're seeing the fruition of this, the good come out of this. But yes, it knocks down those exclusions, which is something I've been arguing for under an equal access for since 1987. And here we are in 2020, and we're seeing that result. But as Jordan said, and I know he's going to underscore, it was 5-4.
Yeah,
Could not have been any closer.
5-4, and on the other side of the aisle, where it's much more outcome-based, everyone knew that. There was literally probably no question in anyone's mind about where those 4 justices would go. There were questions about where John Roberts, I mean, no one had any idea. You realize that I look at these analysts, they don't even try to predict John Roberts.
All right, so we've got Ed White. Ed, give me it was a senior counsel for the ACLJ. Give me your reaction to this.
It is a very good decision today, especially since it addressed the Blaine Amendments, which have been a headache for religious freedom for well over 100 years. And so based upon this decision, the Blaine Amendments, which are in 37 states, should start falling by the wayside, which would allow states to have the option that if they do want to now subsidize private education, they can no longer exclude religious education.
You know, I've written about these Blaine Amendments. And it was anti-Catholic bigotry in the 1850s, 60s, 70s, and 80s. And I wrote I had probably 30 or 40 pages of my dissertation dealt with the Blaine Amendment. And the law review article that we talk about is called "The Story Behind Vidal versus Girard's Executors," is about that. It's the subtitle of my article was "Joseph's Story, the Philadelphia Bible Riots, and Religious Liberty." But the Blaine Amendments, Ed, have been an impediment to religious liberty for literally 150 years.
Oh, most definitely. So here in my home state of Michigan, we probably have the most restrictive of the Blaine Amendments. And as a result, there's no school voucher program, tax credit program. And it does go back in the mid-1800s when you had, after the potato famine in particular, a lot of Irish Catholics, German Catholics were coming to this country. There was a prejudice against them. Blaine in particular, who was a congressman, I think he was the Speaker of the House back in the 1870s in particular, did not want to have any Catholic influence in the country, in particular with schooling. And so that's why these amendments went into place. They tried to become an amendment to the federal Constitution. It failed, but then 37 states have adopted them. And I think over time, the amendments may no longer have that Catholic, anti-Catholic, or even there was concerns about Jewish schools. It became more than a union issue because the public school systems are run by that teachers union. They have a lot of control, and they do not want any money going away from them to go to religious schools. So I think it kind of changed.
Yeah, no, I think you're right. Look, initially it was clearly anti-Catholic bigotry, but what happened here, and I think this is what's so fascinating about this, was it became faith-based institutions or schools, period. Jewish schools, Protestant schools, evangelical schools, charismatic schools, Catholic schools, Muslim schools, whatever. Was the amendment originally designed as a form of anti-Catholic bigotry was then morphed into an anti-religious bigotry. And the Supreme Court today, again, by the narrowest of margins, but still a win. And if John Roberts is right on stare decisis, which he thought he was yesterday, 5-4, that should not change. But, I mentioned, Ed, last question for you. This issue of school choice we're looking at as a civil rights issue. This is important for people that don't have the resources to send their kids to private school.
Most definitely. So even in this Montana situation, I think the tax credit was only maybe $150. So, and that was important to these people who wanted to use that tax credit. So this is an important issue because especially in inner cities where the education system, for example, Detroit, Miami, other places around the country are not very good. Parents who do not have the means should have the option to, from a voucher system in particular, to allow them to send their child to a charter school, a private school, a school maybe outside of the district, so that their child has an opportunity to get a quality education, become a productive member of society. So it is a civil rights issue, but it's an issue in particular that goes to people who cannot afford private education.
All right, Ed White, Senior Counsel for the ACLJ. Thanks for being with us, Ed. Thanks for your insights.
Listen, I know it's been a confusing time for folks. They've been pretty angry with the Supreme Court for the last couple of weeks, and then you get a case like this. But I think this court has been, with this makeup, it's been pretty good with religious liberty. I mean, closest of margins. You lose one justice the other way, and it's 5-4 the other way. Yeah, I mean, if Joe Biden picks the next Supreme Court justice, this case gets overturned.
It could, depending on who that justice is, it could very well. So here's what's interesting is on the religious liberties issues, Justice Gorsuch and Justice Roberts, Chief Justice Roberts, have been very good. So again, it's kind of issue specific, but as Jordan said, you see in the next election, things could change rather drastically.
In these kind of religious liberty decisions, it's not so specific to Montana. Obviously, we had a caller right out of Montana who said, well, this opened the door to us. Yes, but it also opens the door to everybody everywhere that these programs exist. It's a Supreme Court decision. So you might have to litigate at the lower courts, but you won't have to take it all the way to the U.S. Supreme Court if you get it, panel at least acknowledges where the Supreme Court is, which is very clear that under this court for right now, these distinctions trying to say, well, you can go to any school you want as long as they're not affiliated with religious groups. And that includes private schools in a lot of these programs, by the way.
Yep.
And some states were having to adopt this because that's what the laws on the books said to do. And they've said that for 160 years.
Yep.
No problem with precedent there, by the way.
Right.
Overruling 160 years worth of law.
Yeah, so the Blaine Amendments, what happened here is you've got a situation where Montana, like many states, adopts a program where they give credits or vouchers or funding to parents to send the kids to the school of their choice. But in Montana, they specifically excluded faith-based schools, religious schools. That was challenged. Now, I'd had a similar case called Locke versus Davies. I talked about that earlier, where the court ruled against our position, saying that those voucher funds should be able to be used for seminary training. In our brief to the Supreme Court, we said, hey, Locke versus Davies, actually, if you look at it, even with the parts we disagree with, support the idea of neutrality in vouchers. And in fact, Chief Justice Roberts wrote that we have repeatedly held that the Establishment Clause is not offended when religious observers and organizations benefit from neutral government programs, and they cited Locke versus Davies. Also, we wrote about this 15 years ago, and been working on this for a lot longer than that, in a law review article that we published in Pepperdine that I wrote with the colleague Jeremy Tedesco, And it was called The Story Behind Vidal versus Girard's Executors, Joseph's Story, the Philadelphia Bible Riots, and Religious Liberty. And it was an adaptation of a couple of chapters of my PhD dissertation. Well, Justice Alito cited this law review article, which showed the religious hostility. Then it was aimed at Catholics. Now they're using it against everybody. Cited the law review article for the historical context. Then at the oral argument, the issue of Locke versus Davies came up, and the lawyer representing the parents said, "No, wait a minute, Locke actually supports the position." Take a listen.
Respondents argue in the alternative that Locke allows them to exclude the religious schools and that this case falls within the play in the joints. But that would allow the exception to swallow the rule. As Trinity Lutheran made clear, the rule is religious neutrality and Locke only a narrow exception. We argue that Locke is the exception that proves the rule.
And that's exactly, by the way, what the Supreme Court of the United States held by, again, slim majority, 5-4.
Folks, we have a brand new school choice initiative launched by the American Center for Law and Justice. You can check it out at ACLJ.org, but we need your support. I think as you can see through our broadcast and our show today, there needs to be a lot of education here because it is transformative what we're proposing with the school choice initiative. Check it out at ACLJ.org and support the work of the American Center for Law and Justice so we can continue to expand these initiatives.
Folks, the ACLJ is doing work all across the country on all the issues that you care about, all across the world on the issues you care about. And we're able to broadcast it to you because of your support. We're able to do the work in our country because of your support. We're able to do the work internationally because of your financial support. And this is a great time to make a financial contribution to the ACLJ because it's a matching challenge month. What does that mean? We have a group of donors ready to match every donation that comes into the ACLJ right now at ACLJ.org. You're literally doubling the impact of your donation. Your $25 donation, that's what you're charged on your credit card, but that's like $50 for us to ACLJ. No amount too small, no amount too big. It all makes a huge impact. Go to ACLJ.org, be part of our matching challenge, and donate today.
Thanks to your support of the ACLJ, we have had many victories.
The IRS now formally apologizing to Tea Party groups.
If any group feels like they're being targeted, they can go to federal court and bring our case. That's a victory.
It's one of the most significant wins in the ACLJ's history, to take on the IRS and win.
For more than 27 years, the ACLJ has been fighting for freedom and liberty in the United States and around the globe.
These are young people in their 20s and 30s that are doing this, are fighting for life at a whole new level to beat back the abortion juggernaut. But I actually think we're winning this. This is one of the social issues we're winning.
The release of Andrew Brunson.
We're flying and they finally left Turkish airspace. It's like, okay, we're really out of Turkey and free again.
We need your help as we continue this work here in the United States and around the world. Join us online at the American Center for Law and Justice at ACLJ.org.